Welcome to CDH and our Director Law Development Seminar. My name is Ian Hayes and I'm Practice Head of CDH's Corporate and Commercial Department. The role of a director is growing in its challenges and complexities. The focus of our seminar today is to equip directors with the most up-to-date, necessary knowledge and insights required for them to fulfill their duties competently and practice good governance. In our audience today, we have many directors who will benefit from this knowledge sharing directly. We also have company secretaries, legal counsel, and other advisors who we hope will be able to pass on what they learned today to their entities' directors. Our contribution to the development of better directors and better boards we believe, ultimately yield better results and business. Please allow me to introduce our panel of contributing experts on director law developments. We have Yaniv Kleitman. Yaniv's the director in our corporate and commercial practice and operates as our counsel, also known as our oracle. Yaniv specializes in company and securities laws. Roxanne Bain is our corporate commercial professional support lawyer and self-confessed corporate law nerd. Andre de Lange. Andre is the director in our corporate and commercial practice and specializes in corporate law and corporate governance. Andre advises on prominent merger and takeover transactions, as well as listings of companies on the JSE and other exchanges. Akona Mdunge is an associate in our corporate and commercial practice. Akona assists clients with corporate and commercial legal advice, mergers and acquisitions, and provides company secretarial support. Another Akona Mngwaba, is also in corporate and commercial, and she's an associate with experience in mergers and acquisitions, evaluating compliance with corporate governance principles, company secretarial work, and advising on commercial agreements. And then we have Lucinda Rudy, who's the director in our dispute resolution practice and in the corporate debt turnaround and restructuring sector. Lucinda has vast experience in complex commercial litigation matters, corporate debt turnaround and restructuring, Companies Act litigation, financial markets and market abuse litigation, and corporate investigations. And to start things off, I now hand over to Yaniv, who will start the seminar. Thanks, Yaniv.
Thank you very much, Ian. Thank you, everyone, for joining us for the seminar. So on that slide, I've got the outline of the topics, the sequence of the agenda. So I'll kick off with the personal liability of directors and developments in that regard. Roxanne will talk about developments on directors' fiduciary duties, specifically to whom those duties are owed. Andre de Lange will speak about director remuneration aspects. Akona Mdunge, he's our chief executioner when it comes to removal of directors. So there's been a lot of developments in that regard, so we'll hear from him on that. Akona Mngwaba on personal financial interests and conflicts of interests with regard to directors. And Lucinda will take us through various dispute resolution angles, locus standi, how to build a case, and aspects around prescription, the time bar for claims against directors. Okay, so just for housekeeping purposes, each of us will come on and do our bit, full steam ahead in that regard, and then right at the end, we'll have a bit of a Q&A for the panel. Okay, so let's get into director liability. One of the standout features of the Companies Act when it came into force, that's 1 May 2011, was this aspect around the codification of directors' duties and their liabilities, specifically in Section 75, 76, and 77 of the Companies Act. So that was quite a highlight in terms of the Companies Act. By codification, meaning we're going to go through all the books, all the case law, and the common law around directors' duties, and we're going to distill the main causes of action and write them out into the Companies Act. And the idea of that being that it makes those causes of action more certain and more accessible by those who want to pursue those causes of action. And that philosophy has actually borne fruit to some extent. We've seen a lot of cases and a lot of case studies come through in the past few years, much more so, I think, than under the old 1973 Act. So what was never controversial, and this was even before the New Companies Act came into force, is that if a director breaches their fiduciary duties, the company can pursue them for loss or damages. So the company is always a proper plaintiff in that regard. And so that's the main thrust of Section 77 of the Companies Act, giving the company a cause of action to go after the directors for loss or damages suffered by the company. Okay? And to be clear, in terms of when we say loss or damages, it's not necessarily that the company itself must have been impoverished or incurred an expense. If, for instance, the director makes a secret profit or misappropriates a corporate opportunity, that gain in the hands of the director can be clawed back by the company, even though the company itself maybe didn't stand quite a chance to appropriate that corporate opportunity itself. So it didn't suffer really loss itself, but that illicit gain in the hands of the director can be clawed back. So that much is still clear under Section 77. Then another point, interesting one, we don't actually have a lot of development on this point in our law. I was very interested to read it in this case, the Delta property case, which came out a few weeks ago, about a month ago. And it illustrates a sometimes overlooked point that actually wasted time. I sometimes get this question, can wasted management time in pursuing a claim against the director, can that be claimed by the company? And that case held that it can be. Obviously, along with the cost that you pay a forensic investigator, etc., to help build your case and to investigate the matter. So that can be claimed. So if directors and executives of the company are now hugely distracted, embroiled in hours and hours of investigating this claim, you should tell them to put their timesheets in for that, have a schedule of that, and that is in principle claimable from the company. So that falls into the bucket of losses that you could potentially have that the company could claim. So that was an interesting development recently. But then, sort of hovering in the background, was an intriguing provision of the Companies Act, Section 218 sub 2, tucked away in the miscellaneous chapter of the Companies Act. And there was a lot of debate around what this section was saying. And so it says, any person who contravenes any provision of this act is liable to any other person for any loss or damages suffered by that person as a result of that contravention. So quite an astonishing provision if you read it literally. It could mean liability to the whole world. Anyone who's indirectly suffered loss or damages through a sort of knock-on or butterfly effect could sue that director. Someone like a shareholder or even a creditor, perhaps. And that's actually the question. And I'll get to that. And just also bear in mind Section 22, which places a prohibition on the company from trading recklessly or with an intention to defraud creditors. I'll return to those sections shortly, in particular Section 218 sub 2. But then just briefly, an exploration of the business judgment rule. You're probably aware of this. There was a lot of debate back in the 2000s around whether they should introduce this into the Companies Act. Ultimately, they included it in the legislation. And the rule is essentially that if a director had a rational basis for believing that the decision was in the best interest of the company, he reasonably investigated and interrogated the matter to the best of their ability. And they had no personal financial interest, or if they did, they followed Section 75 in disclosing and recusing that interest, then they are deemed to have acted in the best interests of the company and with the requisite care, skill, and diligence. And so the one case study there for Citrus, that was a 2014 Cape Town High Court, where that business judgment rule was successfully invoked by the directors. Interestingly, it was in the context of a clause in the MOI. You find this a lot in private companies' MOIs. They say, the clause says that the board can, even without giving reasons, refuse a transfer of the shares. And the board exercised that right in terms of the MOI. They were challenged by the would-be purchaser. And the board there was concerned about competitors sort of slowly creeping up and taking over the company by way of a series of share transfers. And there the court invoked the long-standing principle that courts will defer to the business judgments of the directors. And so that remains a steadfast principle. Even with all these onerous personal liability provisions, it's still clear judges do not run companies, directors do. And so decisions on matters of policy, strategy, and the business in general will rarely, if ever, be second-guessed by a court. You would have to have a sort of blatantly irrational decision by the board, perhaps. Then maybe a court will descend into the arena. So whichever way, regardless of who can sue you for breaches of duty, the business judgment rule is certainly there. It's found effect in some of the case studies, and it will come to the board's rescue. So that's the point on the business judgment rule. All right, then onto the vital question: who can sue you? Having regard to section 218 sub 2, apart from the company, of course, never was controversial. A point which was settled fairly recently, back in 2020, by the Supreme Court of Appeal. That was the African Bank judgment, Hlumisa Investment Holdings, is that as a general rule, shareholders cannot sue the directors. Okay, so that's the well-established reflective loss principle. That's still part of our law. So what happens there is that the company itself suffers loss through the actions of the directors. The company overpays for an asset, or there's an excessive outflow of funds, or a diminution in profits, etc. So it's the company that suffers the loss, and then obviously as a result, and naturally as a result of this, the value of the shareholders' shares also drops. I mean, on a pro rata basis at least. So when the company is damaged, the shareholders are also indirectly damaged. So is that something that a shareholder can sue the director for? Can they issue summons directly against the directors for that loss in their share value based on section 218 sub 2, this mystical section? And the SCA there held no. The century-old common law on this position still stands. The shareholders' loss is merely reflective of the company's, and it is exactly the same loss. And otherwise, there will be a sort of a floodgates and a double jeopardy issue if both the company and the shareholder can sue you for that very same loss. So when section 218 sub 2 is talking about loss or damages suffered by a person, it is not including reflective loss, because legally speaking, reflective loss is illusory. It's just a mirror image of the company's loss. So it's still for the company through its board to sue that director. If they're successful, the claim goes into the company and inures for the benefit of all of the shareholders. And if the board is not doing that for whatever reason, then the shareholder has to use the derivative action, 165. They've got to go to court and ask for permission to sue on behalf of the company. But then still, it is the company that is pursuing that claim. It goes into the company, the monies that are clawed back, and that inures for the benefit of all the shareholders. It's not the shareholder being paid for loss in share value. So that much was settled. 2020, we have a decision that the shareholders can't use section 218 sub 2. But what of creditors? All right, and I'm now sort of coming towards the end of my analysis here. That remained a lingering question, made even more intriguing when the highest court in the UK said that the reflective loss principle is only a roadblock for shareholders. It's not a roadblock for creditors. Creditors are not blocked by the reflective loss principle. They can pursue those persons that have pilfered the company's resources. And so on the slide there, I've got a sort of typical set of facts that would land on the desk about a sort of a revenge-thirsty creditor who wants to go after the directors of the debtor company. So you have a creditor that has a claim against the company. The company is financially distressed, or it's on the brink of insolvency, which makes the creditor's claim against the company perhaps not worth the paper it's written on. The creditor then alleges that the company's distress or its insolvent position is due to the director's breach of fiduciary duty, breach of Section 76, perhaps also reckless trading under Section 22. You don't necessarily have to use Section 22. You just say you breached your fiduciary duty. That's a breach of Section 76. That's resulted in my creditor claim becoming pretty much worthless. So I'm going after the directors straight for the claim. And so you couple Section 76 with 218 sub 2. And indeed, there were a number of cases that actually went off in that direction in the High Court. The first case was the Rabinowitz case. It planted the seed. That was 2012. And a lot of cases followed in that direction. They said, yes, creditors can use 218 sub 2. There's no need to exhaust the company. Okay. Well, actually, maybe that wasn't so clear. It wasn't clear if you had to show that you couldn't expunge anything from the company. So that aspect was a little bit up in the air. Certainly, you don't have to place the company into liquidation. That much was clear from this line of reasoning. Just go straight after the directors, because Section 218 sub 2 does create liability to the whole world. And very importantly, if you follow those line of cases, you don't have to prove recklessness or fraudulent activities. That's a very exceptional sort of high threshold. You just have to prove an ordinary breach of fiduciary duty, an ordinary negligence under Section 76, and that on that reasoning would be enough for you to go after the directors. But then came the Steinhoff judgment. That was De Bruyn versus Steinhoff 2020 in the Joburg High Court, which actually wasn't about creditors' claims. It was actually about shareholders' claims against directors for misstatements in the financial statements. But the way the court interpreted Section 218 sub 2 there was a turning point, because discernibly after that, the direction of the ship was shifted in another direction. There, Judge Unterhalter said, no, you're all reading this section wrong. You're reading it way too literally. You are making this section the star of the show, when actually it serves a much more mundane purpose. What Section 218 sub 2 is saying is that for the avoidance of doubt, there can in principle be civil liability for breaches of the Companies Act. But as to who is liable to who and for what and under which circumstances, you've got to go into the substantive or the operative provisions of the Companies Act and decipher or interpret the legislature's intention around who is the beneficiary of that section, for whose benefit does that section inure, and those are the persons who can sue under that section. So it's essentially a legal interpretation matter. And so Steinhoff held that Section 212 does not change, 218 sub 2 does not change the fact that directors owe a legal duty to the company, not to individual shareholders and certainly not to creditors. I can maybe put an asterisk there. Rox will have a little bit more on that. But for the time being, it can be accepted that it is the company that is the beneficiary of the fiduciary duties, not the whole world. And that's why we have Section 77 as a specific liability provision in favor of the company. Yet still, even after Steinhoff, the decisions in the High Court were maybe still a little bit all over the place, because you didn't have a superior court that bound all the High Court judgments until Venator. Until the Venator case in the SCA, that was last year, settled the matter, for now at least. It's not inconceivable that something like that can go to the Constitutional Court. It is a matter of public interest, but for now we have the SCA judgment that is basically saying that the Steinhoff judgment in the High Court is correct. The reasoning applies to creditors as well, and it is generally speaking the company and the company only that can sue its directors for a breach of fiduciary duty. So, after this winding road, where are we with the creditors in terms of their available remedies to go after directors? And look, one is essentially going to have to go back to these sort of traditional modes of attack, so to speak. Obviously, first and foremost, the best protection you can get as a creditor is a contractual protection. I mean, get a suretyship or get a guarantee from the directors of the company. Then you don't have a debate around breach of fiduciary duties, etc. The borrower company has not paid, so you must pay, and that's the end of the matter. So that's probably your first and foremost most important type of protection that you get. Section 424 of the Old Companies Act 1973 is still there, but it applies only in liquidations. That's because the transitional provisions of the New Companies Act preserve the Old Companies Act only for purposes of the winding up of companies. So when you put the debtor company into liquidation, Section 424 can be used, and anyone who participated in reckless or grossly negligent or fraudulent activities of the company can be held personally liable for the debts of the company. But you've got to put the company into liquidation. Piercing of the corporate veil, yes, in principle, you might be able to use it. It's a highly exceptional remedy, though. You have to show that that company is basically a fraud or a sham. It was never really a genuine company. It's not treated or respected in terms of its separate juristic personality. Then yes, you can regard the debts of the company as being the debts of the controllers or the directors of the company. But as I say, quite an exceptional remedy. And then lastly, we don't have a case on this yet, but it remains an intriguing candidate, Section 129 sub 7 of the Companies Act. That's tucked away in Chapter 6. That's your business rescue provisions. Quite a controversial section that says when a company is financially distressed, as defined, it's going to go insolvent in the next 6 months, or there's a reasonable likelihood of that happening. The directors of the company must send a notice to all affected persons, including creditors, telling them of this fact, that it's, the company is financially distressed, and explaining to them why they're not putting the company into business rescue. A lot of companies don't comply with this and never will for obvious reasons. But it's an intriguing question that if you don't send that notice out to your creditors, and your creditors go deeper and deeper in with the company and advance more and more credit, and then eventually the company goes bust and your claim against the company is worthless, is Section 129 sub 7 perhaps something that the creditors can use to go after directors? Because it's arguable that that section is for the protection of creditors, and that maybe it's distinguishable from that general venator type of reasoning that the fiduciary duties are owed to the company. Here, there's a statutory duty that is owed to actually creditors, I would argue, to notify them of the financial distress. If you haven't done that, potentially there is director liability in that regard. Okay, so that's the latest technology we have on director liability. Thank you again. I will hand over to Rox. Thank you.
Morning, everyone. Thank you. Okay, so I'm going to be discussing fiduciary duties of directors, particularly the duty to act in the best interest of the company and what is meant by company. Then I'll look at some practical examples of breaches or not breaches of fiduciary duties, including examples of where the breach was so egregious that it actually warranted a declaration of delinquency. So for context, I'm just going to start by going through the core fiduciary duties of directors very quickly, and then the grounds for a declaration of delinquency. Okay, so directors' fiduciary duties are regulated by the common law and partially codified in Section 76 of the Act. So just quickly, in terms of Section 76, directors mustn't use their position or information obtained while acting as directors to gain a personal advantage or advantage for any person that is not the company. So here we're really dealing with the no secret profit rule and the corporate opportunity rule. So directors cannot make a secret profit by virtue of their position. They also cannot appropriate opportunities that rightfully belong to the company for their own personal benefit. And then linked to this is the no conflict rule, which is that directors mustn't place themselves in a position where their personal interests conflict with the interests of the company. And then not to knowingly cause harm to the company or a subsidiary of the company. And then the kind of core fiduciary duty here is directors must exercise their powers and perform their functions in good faith and for a proper purpose and in the best interests of the company. Okay, and then just quickly the grounds for delinquency. So firstly, the effect of delinquency. If a director is declared delinquent, it means that person cannot act as a director for as long as the order persists. And the purpose of a delinquency declaration is basically to protect the public against directors who engage in serious misconduct. So just very quickly, in terms of section 162 sub 5, a court must, it doesn't have an option, it must declare a director delinquent if that director grossly abused the position of director, took personal advantage of information or opportunities that belong to the company, intentionally or by gross negligence inflicted harm on the company or a subsidiary of the company, or acted in a manner that amounted to gross negligence, willful misconduct, or breach of trust, contrary to sections 77 sub 3a, b, and c, which deal with lack of authority for actions like reckless trading and fraud. So declarations of delinquency subsist for a minimum of 7 years or a longer period as determined by the court. Okay, so what is meant by best interests of the company? In other words, who is the company in this context? So traditionally, we are talking about the shareholders here, the shareholders as a collective body, both present and future. Okay, so other stakeholders, such as customers, suppliers, creditors, employees, the environment, the community in which the company operates, these stakeholders don't have any formal legal recognition under the Act. Okay, so there is an argument for a stakeholder inclusive approach, and we know that the King Code, for example, very much emphasizes stakeholder inclusivity, and the King Code is actually becoming a yardstick for measuring fiduciary duties, as we will see in the Outer versus Myeni case, which I'll discuss in a minute. But ultimately, the King Code is a voluntary code in most instances, and stakeholder inclusivity, although it is becoming increasingly important, especially for large listed companies, is very much a corporate governance issue for now. As I said, there's no formal legal recognition under the Act. Very importantly, the fact that shareholders have primacy doesn't mean that shareholders have a direct claim against directors for breach of fiduciary duties. As Yaniv mentioned, the company is the proper plaintiff in these scenarios. Okay, so just to take a look at an example from case law, examples from case law. So the first one there is BTI versus Sequana, which is a UK Supreme Court case from 2022. And here the meaning of best interests of the company was interrogated, and the question was, can this ever mean the best interests of creditors? So just briefly, the facts here. A company called AWA declared a dividend to its shareholder Sequana, and the dividend was declared completely lawfully. The company was solvent at the time. All the requirements in the UK Companies Act were met. But at the time, the company had some uncertain contingent liabilities, and there was some uncertainty as to the value of its assets. So there was a risk of insolvency in the future, though insolvency at that point wasn't imminent or even probable. However, the company did eventually become insolvent, I think about 9 or 10 years later, and the appellants instituted proceedings against the directors on the basis that the directors had breached their duty to creditors in approving this dividend. So they had not acted in the best interest of creditors. And so the court had to decide, is there a creditor duty at all? And they said, like the South African Act, the UK Act codifies the common law duty to act in good faith and in the best interests of the company. And the court said sometimes this is modified such that the best interest of the company is taken to mean the best interest of the creditors. Okay. And the court said this is an aspect of the duty to act in the best interest of the company. It's not a freestanding duty directly to creditors. But nevertheless, there is this creditor duty, and the court justified its existence by saying that although creditors always have an economic interest in the assets of the company, the relative importance of that economic interest increases the closer the company gets to insolvency. So the court said the greater the company's financial difficulties, the more the directors should prioritize the interests of creditors in exercising their powers. So it's kind of like a sliding scale. Interestingly, though, the court said on these facts, the creditor duty actually wasn't engaged. It wasn't triggered. So at the time that the dividend was declared, the company wasn't actually or imminently insolvent, and insolvency wasn't probable at that stage. So the court said the fact that there's a risk of insolvency is not enough. Rather, the creditor duty is engaged when directors know or ought to know that the company is insolvent or bordering on insolvency, or insolvency is probable. Okay, so of course this case is not binding in South Africa, but it could have persuasive force if a South African court was ever faced with a similar set of facts. Okay, then some further examples, turning to South African law. Firstly, Modise versus Clade Holdings. So here, very briefly, Modise, he was a director of Clade, and he had been mandated to secure a particular opportunity for Clade, namely shares in a company called ARB. It's quite a long, complicated set of facts, but to cut a long story short, eventually ARB said to Modise, we want to offer the opportunity to you in your personal capacity. And Modise took the offer up in his personal capacity. The court held that Modise had breached his fiduciary duties, and particularly the corporate opportunity rule, which I spoke about earlier, for various reasons. Firstly, Clade had been actively pursuing this opportunity. It was integral to Clade's business strategy, and Modise had actually been expressly mandated to pursue it. Modise failed to disclose the opportunity was offered to him and concealed it. Once he took it up, he kind of dropped off the face of the earth and was uncontactable by Clade. And the court said, very importantly, it's irrelevant that the opportunity would not have materialized, or that the third party, in this case ARB, wanted to deal with the director personally. Okay, then another one, Smuts versus Krommelboog Conservation Services. This was a delinquency application. So here, a director, Smuts, was removed by the shareholder of Krommelboog. In terms of Section 71 of the Companies Act, there was a breakdown in the relationship between Smuts, the director of Krommelboog, and the shareholder. And the following conduct formed the basis of a delinquency application. So minutes before the meeting to remove Smuts, he completely emptied the company's bank account. He took out about 300,000 Rand, left 10,000 Rand in the company's bank account. Shortly after his removal, he then froze the company's bank account. So the company didn't have access to its bank account for many weeks. He used company funds for his personal legal fees and invoiced the company for what he called consultation fees, which apparently included him preparing for this meeting to remove him. And he caused the company to donate money to another entity in which he had a personal financial interest without the necessary approvals. So the court held here, clearly there's a conflict of interest, gross abuse of the position of director. He inflicted harm on the company, and there was gross negligence, willful misconduct, and breach of trust. Then the rather famous Outa versus Mjeni case, also a delinquency application. So this application relates to a time when Dudu Mjeni was the non-executive director and chair of South African Airways. A very detailed judgment from a factual matrix perspective, but I'm going to try and just get to the point. Basically, this involved two transactions which were very beneficial for SAA and which SAA desperately needed to go through, not only to secure an income stream, but also to avoid business rescue and or liquidation. And Mjeni basically did everything in her power to stop these transactions from going through. And the court ultimately held that there was no rational basis on her part for blocking these transactions. Almost all the grounds for delinquency were met. King 3 the court referred to this, and King 3 was applicable at the time, and SAA had bound itself to King 3. And the court referred to the principle that the chair is responsible for setting the ethical tone of the board, and a failure to do that could be an indication that you're not complying with your fiduciary duties. And then just two further important principles that the court highlighted here is that the fact that the directors have collective responsibility for the management of the company does not absolve them from liability on an individual basis. And also importantly, non-executive directors and executive directors have the same fiduciary duties. So you can't hide behind the fact that you're a non-executive director. And Myeni was declared delinquent for life. This was the first case where a director was declared delinquent for life. Okay, and then lastly, the Delta Property Fund versus Nomvete case. Sorry, there's a mistake on the slide there. It should be the High Court. This was just handed down a few weeks ago. It involved 4 causes of action involving 3 ex-directors of Delta, namely Nomvete, Maharaj, and Chabalala. And they were all involved in the different causes of action to varying degrees. But just to go through it very briefly, so the first cause of action was the Bank of China transactions. So Delta had a loan in place with Bank of China, and this loan was extended on a number of occasions. But in the case of 2 of those extensions, the 3rd and the 5th extension, Nomvete and Maharaj actually engaged an employee of Bank of China in their personal capacity to secure the extension of the lease in exchange for a fee. And the court said, well, this is a bribe and it's unlawful. It amounts to a breach of fiduciary duties. There was a deliberate attempt to conceal the payments, and it was dishonest, corrupt, and criminal. Then the Mshlandla and Zimzen transactions. So Delta leases property to the government, mainly the Department of Public Works. And Nomvete, with the knowledge of Maharaj and Chabalala, caused Delta to enter into agreements mandating 2 companies with ties to Nomvete to secure extensions of these leases within a particular period in exchange for a fee. Millions were paid, tens of millions were paid to these companies, but it turned out that most of the lease extensions were outside of the mandate period, and there was no evidence that these companies were actually the cause of the extensions. It also transpired that one of these companies paid an amount of money to a company, and the sole director of that company was, you guessed it, Nomvete, just as the mandate was expiring. And the court said it seems that Nomvete was getting a secret profit from these lease extensions. So the court there held again breach of fiduciary duties, recklessness, dishonest conduct. A secret profit was received, and there was a breach of the no conflict rule in that Nomvete didn't extricate himself from dealings with 2 companies that he had close ties with. And then the EPF transactions. So this is the 3rd cause of action. Delta leased property to EPF, and a friend of Nomvete was the sole director of EPF. And that lease had a restriction in it that the property couldn't be sublet for an amount higher than what was being paid under the main lease. And Delta was represented by Nomvete here. But before the main lease was even entered into, EPF had already sublet the property to a municipality at a higher rental than the main lease. And the explanation that was given was that the municipality needed to urgently obtain this property, but couldn't meet its tender process requirements, and so couldn't give the new lessor the comfort that it had met its requirements. And EPF said, well, you don't need to give us that comfort, we can go ahead. So it was a transaction which facilitated the municipality not complying with its tender process requirements, and EPF, to which Nomvete had ties, effectively swindling the municipality out of millions of rands over a number of years. It resulted in the breach of the agreement with Delta, and in the process exposed Delta to malfeasant conduct. So the court said this was a corrupt transaction and amounted to a breach of fiduciary duties. And then the last cause of action, the shameless way transaction. So Nomvete and his wife are sole directors of a company called Shameless Way. I think the irony of that is lost on absolutely no one. So Shameless Way owns a private aircraft, and its business is to provide chartered flights. And Delta hired this aircraft on a few occasions without compliance with the business travel policy. And Nomvete presented the invoices to Delta, and Maharaj signed off on them. And the court held again, breach of fiduciary duties, not in line with the travel policy. You had a personal financial interest in this matter. And it exposed Delta to allegations of nepotism and reputational damage. So ultimately, Nomvete was declared delinquent for life, Maharaj for 15 years, and Shabalala for 7 years. Okay, so now you know what not to do. Thanks, everyone.
So good morning. So today I will be dealing with directors' remuneration and developments in respect of that. So firstly, I think that we're probably all aware that globally there's really a focus on remuneration of company directors and senior executives. And it really arises out of a concern around the equity in respect of remuneration between stakeholders in the company. Also, the high levels of income inequality within companies as well as in society in general, and then concerns around the reasonableness of remuneration in companies. So what we've seen internationally, it has been quite an evolving regulation over time. So firstly, there was a disclosure requirement to shareholders, and this then developed over time into a disclosure requirements plus a non-binding advisory vote by shareholders on the remuneration policy as well as the implementation report. And in time, and this is where we are coming to now, is where we are seeing binding votes by shareholders on the remuneration policy and implementation report. So in South Africa, we've also followed that same process, evolving regulation. Firstly, the Companies Act in 2008 had specific disclosure requirements, then King recommendation on non-binding advisory votes, JSE listings requirements, and then where we are today is with the Companies Amendment Act, that there are certain enhanced remuneration provisions in the Companies Amendment Act. These have not yet become of force, but it has been signed into law, and we are waiting for the operative date of those provisions. So I'm just going to deal with these different South African law provisions and just highlight some of the changes that has recently come into play. So firstly, in terms of our 2008 Act, there was the requirement that if a company pays remunerations to its directors for services as directors, then the company can only do that if it has been approved in advance by a special resolution within the past 2 years. Normally what you would see in AGM notices is that companies would then get the approval for this by special resolution, and then will be able to then pay the directors for these services. It is important to note that these are really directors' fees that we're talking about. So we're not talking about services that directors also provide to the company in a different capacity, for instance, as an employee. So those services fall outside of the ambit of Section 66(9). Then, in terms of Section 34 of the Companies Act, there is a disclosure requirement on companies to disclose certain remuneration in their audited financial statements. And these only apply to companies that are required in terms of the Companies Act to audit their annual financial statements. And they are typically public and state-owned companies and other companies that in respect of a certain public interest score or the holding of funds as fiduciary, or that is required in terms of the MOI to have their accounts audited. So the requirement in terms of the Act is that there has to be disclosures in respect of directors as well as prescribed officers. And these disclosures should include a number of things that's listed there: directors' fees, salary, bonuses, etc., expense allowances. And what's also important is that it also applies to certain fees paid to directors of the companies for services in related companies. So it's not just for services in the specific company. Then there was always a bit of uncertainty as to in what detail should you disclose these fees, and should you, can you just put an aggregate number that all the directors receive X number, or should you name the specific people? So this, in terms of the Companies Amendment Act that was that came into operation in December last year, it has made that clear that you now have to disclose the remuneration for each director. You have to name the director. I think that is something that our firm is always, it was always almost our house view that that is the type of disclosure that is required, but there was some uncertainty in respect of the Act. So then what is also important is in the past, the annual financial statements of companies were generally only available to the shareholders of the company. So these detailed disclosures would not really be known to members of the public, people out there. But there's now an amendment that has been proposed in terms of the new Companies Act, in terms of the Companies Amendment Act. This has not yet become into operation, but it is there, and we are awaiting the operational date of that in due course. And what this says, it amends Section 26 and provides now that any member of the public will have the right to access the annual financial statements of really any company, except for smaller companies, that actually those companies that do not have to audit their annual financial statements. So in future, any member of the public can come to the door of the company and actually request to inspect the annual financial statements and also to make a copy thereof. So this is quite a big change, and larger private companies are no longer so private. I mean, this information would now be available to competitors, creditors, labor unions, etc. Okay, so that is the Companies Act of 2008. Then King 4 was published in 2016, and it really provided that the company should prepare a remuneration policy, and that this policy should address company-wide remuneration, fair and responsible remuneration to executive management, and all elements of remuneration. And then it also recommended that companies at their AGMs on an annual basis present a non-binding advisory vote on the remuneration policy and the implementation report. Then if more than 25% of the votes are exercised against these reports or the policy, the company should then engage with its shareholders, and at the next AGM they have to report back on how they took account of the concerns of the shareholders. After the publication of King, the JSE listings requirements amended its listings requirements and provided that for companies listed on the exchange, these recommendations regarding remuneration of King is compulsory for listed companies. So then all listed companies now had to comply with these provisions. So now we get to the Company Amendment Act that was published last year, signed into law. And it now, for the first time, introduces enhanced remuneration provisions in the Companies Act. But I think it's important to note that this has not yet come into operation. We actually don't know why not, and we actually don't know exactly when it will come into operation, but it is probably imminent. So people will have to start thinking about this and to start looking as to how they can comply with it. Now, the stated objectives of these changes are really to address those concerns that shareholders and the public have with remuneration in companies. But it's also important that it only applies to public and state-owned companies. So it doesn't apply to private, non-profit or personal liability companies. And effectively, the regulation provides that companies should prepare a remuneration policy. The Act doesn't say what the contents of the policy should be, but you should probably look at King 4 for guidance on that. And then every 3 years, you have to present that policy, remuneration policy, to your shareholders at the AGM for approval, or earlier when any material changes are made to the policy. And then at that AGM, this is now a binding vote of shareholders. They have to approve the policy by way of an ordinary resolution. So it's a 50% plus 1. So it is, in a sense, a lesser requirement than King, because King effectively had a 75% approval requirement. And then importantly, our interpretation of the provision, or my interpretation, I don't know whether Yanif agrees with that, is that you cannot implement the policy without approval. So you have to get it approved to implement it. So then the second requirement of the Act is that you have to prepare a remuneration report, and that report should consist of a background statement, copy of remuneration policy, and then an implementation report. And the Act is quite specific as to what this implementation report should contain. Firstly, the total remuneration of each director and prescribed officer. The Act has a definition of total remuneration, so you have to look at that, and it's probably everything conceivable that you can pay a director or prescribed officer. You have to then disclose the total remuneration of the employee in the company with the highest earnings and the one with the lowest earnings. And then the average medium remuneration of all employees, remuneration gap reflecting the ratio between the total remuneration of the top 5% and the bottom 5% earners. This remuneration report has to be approved by the board, and then on an annual basis has to be presented to your shareholders for approval by way of an ordinary resolution. So again, it's not a non-binding, it's a binding vote. So if the remuneration policy is not approved, it must be presented at the next AGM or special shareholders meeting until it is approved. As I said, you cannot implement the policy without the approval. If the remuneration report is not approved, then the remuneration committee must explain at the next AGM how the concerns of shareholders was taken into account. And then importantly, the non-executive directors serving on the remuneration committee must stand for re-election as members of that committee at that AGM where they had to explain how the concerns were taken into account. So this is an interesting one, because if you think about it, the remuneration committee is actually appointed by the board. They're not appointed by shareholders. But now, if the report is not approved, the shareholders now appoint the remuneration committee. Then, if at that AGM for the second time the report is not approved, then the non-executive directors that serve on that remuneration committee must actually stand for re-election as directors at that meeting, and they may not serve on the remuneration committee for a period of 2 years thereafter. This will probably lead to people not really wanting to serve on the remuneration committee. So practically, this is an interesting one, because at that second AGM, you're not going to know whether the report is going to be approved or not. So you will probably have to include a conditional resolution in your notice of AGM to say, conditionally on the report not being approved, the following people stand for re-election as directors. So then, what is the interaction between the Act and the JSE? Listings requirement in respect of this aspect. So following the publication of the Act, the JSE published certain amendments to the listings requirements. It's not yet enforced. It will come into force when these provisions come into force. But effectively what it says is that for South African companies, that's governed by the South African Companies Act, the JSE takes out all provisions regarding remuneration. You don't have to comply with King, but you have to comply with the provisions of the Companies Act, because the JSE feels that is sufficient. In respect of of foreign companies. Those are companies that's not subject to the South African Companies Act. With a primary listing on the JSE, they will have to comply with the old King requirement. But the 25% threshold to start engaging with shareholders has been lowered to the 50% threshold to align with the provisions of the Companies Act. And I think interesting, the Act, the company that has to do these disclosures in their implementation report, they have to disclose remuneration in respect of their employees. And a question that arises is in a group company where you have the group public company that effectively has got no employees, and then they've got the subsidiaries where the employees are employed. What does that company do? Do they just disclose nothing because they don't have any employees, or do they have to disclose on a group level? So I think the jury's still out exactly how that is going to be treated, and perhaps in regulations it might be clarified exactly how that would work. It would also be interesting whether shareholders would allow companies to report on that basis, where they actually just report nothing. Now, the question that arises is how effective are these provisions? Is it really going to lead to all the positives that is aimed at to achieve? Will companies want to disclose the lowest paid employee salary, or would they just outsource their people? Would the disclosure of executive remuneration, often it doesn't lead to a lowering of the remuneration. It's almost a benchmarking exercise. So it is actually unclear exactly what the effectiveness of this will be. It's also unclear what the role of shareholders would be. Will they take an activist role and start really ensuring equity in remuneration, or will it just be business as usual? So we don't know where that will end. So we just did a bit of a desktop exercise. I did one of these presentations to a board of directors, and the chairman, when I went through this slide, they said, "But this is ridiculous," and where does it? And I said, "No, but there's actually international precedent for it." And the guy said, "But what decent country has something like that?" And I said, "I think Australia." And the guy said, "Exactly my point." So in any case, so I think the lessons, desktop is the lessons that you can take out of the international comparators. Mostly they apply, these type of provisions apply to public companies and to normally listed companies. There's normally a disclosure requirement, and there's a combination of a binding and non-binding votes. And then interesting, Australia is an interesting one where they have a non-binding advisory vote on remuneration report. And if at 2 consecutive AGMs, over 25% of the votes are against the report, then there's a spill resolution put to shareholders to determine if all the directors are required to be re-elected. So that's but almost, there's some aspects of ours. I think if you look at this internationally, it does appear as if South Africa, our regulations are quite onerous compared to other jurisdictions. And you probably have to see it in the light of our society and the income inequalities in our society. So that is probably the context in which we have to see this. So thank you very much. I now hand you over to the first of our corners.
Thank you, Andre. Good morning, everyone. Let's kick off with unpacking the process whereby a director is removed by other members of the board, which is the more difficult process. Our governing provisions in this regard are sections 71, subsection 3, 4, and 5 of the Companies Act. Subsection 3 provides that if a company has 1, 2 or more directors, and an allegation has been put forward by a director or a shareholder of such company that a director has become either ineligible or disqualified, incapacitated, or negligent or derelict in the performance of their functions as a director, then the board of that company, other than the director concerned, may pass a resolution determining such director as meeting these requirements and resolve to remove that director from the board. So let's unpack this process by way of a worked example. And I looked at the attendance register for familiar names for this purpose. We have, hypothetically speaking, a company whose board comprises myself, Vuyani, and Manfred. We have Fatima and a trustee as equal shareholders in this entity. Trustee advances an allegation that I have I've breached one of these provisions of Section 71, Sub 3 of the Companies Act. A meeting of the board is accordingly convened, which complies with procedural requirements, which I'll touch on later, in that I'm given notice of this meeting of the board, which sets out the time, date, and venue of this meeting. I'm given the proposed resolutions, which are going to be passed at this board meeting, as well as a statement setting out the reasons that I'm going to be removed as a director. And this is provided to me in sufficient detail to allow me to prepare a presentation to the board as to why I should not be removed as a director. Before making the determinations contemplated in this subsection, it is important to consider what Vuyani and Manfred would have to conclude before resolving to remove me as a director. With ineligibility and disqualification, it's simple enough because they could have considerations of provisions of Section 69, which lists that criterion, as well as the provisions of the Companies Act or the Memorandum of Incorporation of the company. Capacity, well, here they'll have to determine that I am experiencing some form of injury or ill health, and that I'm subsequently precluded from performing my functions as a director, and that I'm unlikely to regain that capacity within a reasonable point of time. What about negligence or dereliction of duties as a director? Another apparently difficult conclusion of fact and law, which Vuyani and Manfred would have to come to, in that they would have to consider the provisions of the Companies Act, the Memorandum of Incorporation of the entity, as well as the common law to find that I've breached my duties as a director in this regard. What further makes these determinations a little bit more tricky is that I, as a director, subject to this removal, have right of recourse under Section 71, Sub 5 of the Companies Act to review the decision passed by Manfred and Vuyani to remove me as a director of the entity. And this is exactly what happened in the judgment in the case of Jones v. Delport. Allegations had been advanced that certain directors of the company had become negligent and derelict in the performance of their functions as directors. The other directors on the board had found there to be merit in these allegations and resolved to remove the directors in question. The aggrieved directors thereafter follow their rights to review this decision in terms of Section 71, Sub 5 of the Companies Act. Some of the interesting points that come out of this judgment is that when such a review application is placed before a court, the court advanced that it is not constrained to consider only whether or not the procedural requirements were followed to remove the director in question. Depending on the facts of the case, it's one of those circumstances where the court held that it can descend into the arena to consider the facts before the board at the time of passing the resolutions to see whether or not there was sufficient evidence which justified the conclusion which is reached by the board of directors. What is accordingly required for a removal in terms of Section 71, Sub 3 is procedural and substantive fairness in the process. Given this high standard for removal of a director by other members, consideration should always be given to obtaining independent expert advice regarding the conclusions of fact and law that need to be reached when removing a director in terms of Section 71, Sub 3. Getting back to our worked example, let's say that the Memorandum of Incorporation of the company contained a provision which allowed Vuyani and Manfred to sign a notice and deliver it to a company in terms of which they agree that I must be resigned as a director of the entity. What such a clause achieves is that it alleviates these cumbersome procedural and substantive requirements that we've discussed previously. It's easier, accordingly, for the board to remove me as a director of the entity. But it, however, calls into question whether or not a removal on this basis is valid. The resignation of a director by other members of the board in terms of this very clause on the screen was challenged in the case of Golden v. Quantum Foods. The primary challenge was that this clause was inconsistent with the provisions of Section 71, Sub 3 and 4 of the Companies Act, being the procedural requirements that we've just touched on. The Western Cape Division of the High Court here held that because this clause cannot be tested against the principles of justification, it is in breach and in violation of the values of our Constitution as well as public policy. The director removal accordingly on the basis of clause of this nature was held to be invalid. Back to our worked example again. Recognizing the cumbersome nature of removing me as a director in terms of Section 71 Sub 3 of the Companies Act, trustee now makes a demand to the board to convene a meeting of the shareholders to remove me as a director. Our governing provisions in this regard are Section 71 Sub 1 and 2 of the Companies Act. Section 71 Sub 1 is straightforward enough because it provides that a director may be removed by an ordinary resolution of the shareholders. Subsection 2 speaks to the procedural safeguards that must be followed prior to my removal as a director. The standard formality requirements set out in the Companies Act for a removal of a director must accordingly be followed. I would, accordingly, be entitled to receive notice of the meeting convening the meeting of the shareholders, which would have to set out the date, time, and place of the meeting. The proposed resolutions to be passed by the shareholders would also have to be set out in the notice. These compliance provisions should also be followed in circumstances where a company only has one shareholder for the removal filing reasons that I'll touch on later. But does the notice convening the meeting of the shareholder need to provide reasons as to why I'm being removed as a director? Well, this was one of the reasons that the board in the judgment of Beso Investments v. Capeco Development had argued prevented them from circulating a valid notice convening a meeting of the shareholders. The Eastern Cape Division of the High Court rejected this argument, finding that a shareholder is not required to advance reasons for the removal of the director at the same time that they make a demand for a meeting of the shareholders to be convened. This, the court advanced, is because directors, when they no longer have the support of the shareholder and the shareholder wishes to remove them from the board, are not entitled to reasons for their removal. This position is supported by a recent tide of High Court judgments which are deviating away from the principle that emerged in Pretorius v. Timka. In this case, which was decided many years ago, the court had found that because directors under Section 71(2) Sub B of the section have a right to make a representation regarding their removal, reasons must accordingly be given to them by the shareholder as to why they are being removed. Failing which, the court found, it would render the provisions of Section 71(2) Sub B superfluous and without effect. However, the Gauteng Division of the High Court's judgment in the recent case of Miller v. Natmet Defense found that the removal provisions in Section 71, Sub 1 and 2 do not require the shareholders to give the directors they no longer support reasons for their removal of the director. This view is also found in the decision of Jones v. Dalport, which we touched on above. If you go through academic commentary on this point, you do find that some academic commentators advance arguments against this developing tide, arguing that the provisions of Sections 71 Sub 2, Section 71 Sub 1 and 2 would allow for shareholders to make a predetermined decision to remove a director, and that there would be no way in determining whether the shareholder actually considered the representations which were made by the director prior to their removal. Notwithstanding this growing tide of High Court judgments finding that a director is not entitled to reasons for their removal, practically, when updating the records of the company with the CIPC, this is the practice note which currently sets out what must be filed to update the company's records in this regard. And you'll see that the second point states that a statement setting out the reasons for the removal must be provided to the director in question. While not giving reasons would not render the resolution passed by the shareholder invalid, it will make the the process of updating the records of the company with the CIPC more difficult and also delay this process. And we've seen this cause problems with our clients with, for example, being able to open bank accounts or change their bank accounts when they haven't been able to update the records of the entity. Accordingly, until a new practice note is issued by the CIPC, which from our recent correspondence with the CIPC late in January, will probably be when a Supreme Court of Appeal or Constitutional Court judgment is issued resolving on this point, please do follow the approach of including reasons in your notices convening the meeting of the shareholders to remove a director. Of course, such reasons do not need to go into sufficient detail or a lot of detail setting out why the director is removed, and high-level reasons we've found are sufficient to get this across the line with the CIPC. This would then accordingly wrap up my removal as a director by trustee, and I can now hand over to Akona Mgwaba to take us through personal financial interests. Thank you.
So good morning, everyone. As Akwana's mentioned, I'll be taking us through directors' personal financial interests. And this takes us straight into Section 75 of the Companies Act. There is an interplay here with the common law, as I'll describe in a minute. But Section 75 essentially deals with the duty of a director to not have a personal financial interest in a contract of the company or a matter in which the company has a material interest in. And so this sort of branches off of the more broader common law duty for directors not to have any conflicts between their interests and that of the company. And essentially, as Roxanne mentioned earlier, directors shouldn't place themselves in any position where their personal interests conflict with the interests of the company or their fiduciary duties that they owe to the company. So out of this no conflict rule, as it's more commonly known, a number of other duties also flow from it. So we see that there's the duty to disclose an interest in a contract with the company. So we see this couched inside Section 75. There is the duty to account for secret profit, the duty to not misappropriate corporate opportunities, and the duty not to improperly compete with the company as well. And so these common law conflicts of interest aren't necessarily excluded by Section 75. Section 75 does act as a partial codification of some of these no conflicts, some of these conflicts of interest, common law conflicts of interest. But we do find that there may be instances where, or situations where the facts of the case don't squarely fit into Section 75, or Section 75 doesn't find applicability. And here, it should still be assessed whether there is a common law conflict of interest. And in doing that and making that inquiry, this should be you should take a common sense approach to this. But where Section 75 does apply, it essentially will require a disclosure of your personal financial interests and recusal from the decision making and the deliberation on the matter. So Section 75 needs to be read together with the definition for personal financial interests, which we find in Section 1 of the Companies Act. And the definition says it's a direct material interest of a person of a financial, monetary, or economic nature. And it explicitly excludes an interest that a person holds in a unit trust or a collective investment scheme, unless the person has direct control over the investment decisions of that fund or the investment. And so we see there is a huge emphasis placed on this requirement for direct material interest. I've set out two cases here which sort of discuss this, but we also just want to contrast, I do want to contrast this definition of personal financial interests, which, emphasizes this direct requirement with, the common law, where directors, in terms of the common law, directors are prohibited from having an interest in a contract with the company, whether the interest is direct or indirect. But we see, obviously, in the definition of personal financial interest, it doesn't include an indirect interest. So in the case of Atlas Park Holdings, it was held that for purposes of the facts of this case, a shareholding held in a company which has an interest in the relevant transaction, other than a unit trust or collective incentive investment scheme, this shareholding will amount to a direct personal financial interest. That does require disclosure in terms of Section 75. And so there is commentary that says that although the court qualified this statement by making reference to the particular facts of the case, the principle would obviously ring true in other cases that have similar facts or similar situations, and it does, cover in certain circumstances this indirect element that we see under the common law. And so in the Dimension Data Facilities case, I know this is quite a topical case at the moment, but the facts are quite complex and there's also a number of role players, so don't want to get too bogged down in that. I think for purposes of our discussion regarding this directness requirement, I think a key takeaway was that, even in cases where there is intricate or layered ownership structures that have been interposed by directors that make it maybe not as easy to ascertain their interests. One can still look through these, and the court held that Section 75 can't be used to evade, or these structures can't be used to evade Section 75, especially where they appear to conceal the director's interests. So the court also said that the requirement of a direct personal financial interest under Section 75 does not mean that the requirement needs to be held in the director's personal capacity. It is an interest that can be discernible by reference to the matter to benefit the director directly. And so I do understand that the case has been taken on appeal, so we'll just have to see what happens there. Maybe there's going to be a further development. But I think what these two cases do demonstrate is that, the requirement for directness in the definition for personal financial interests, it can include an interest which, on the face of it may appear indirect. I mean, you see in the Atlas case that, shareholding in a company that has a interest, that in itself, one would feel that that's maybe indirect, but as the court has held, it does qualify as a direct personal financial interest. And so where we see Section 75 maybe causing some difficulties or a bit of a challenge is particularly in the context of intra-group transactions. It all sort of turns on this definition of a related person. So we see in Section 75(5) that if a company knows that a related person has a personal financial interest in a matter, they also have to disclose this and recuse themselves. And in terms of Section 75, the definition of a related person is expanded to, not only include the definition in terms of Section 1, but it includes a second company of which a director or related person is a director of, or a closed corporation of which that director or related person is a member of. So what practically can happen is that there could be two companies that fall under the same group or have the same holding company that want to enter into a transaction with each other. All the common directors in these companies would have to disclose that by virtue of the fact that they are directors on the board of the other company, that company would constitute a related person to them for purposes of Section 75. And so that company would obviously have a personal financial interest, given that they're a counterparty to the transaction or the agreement. And so these common directors would have to recuse themselves from the meeting, and this would result in a reduced number of directors on the board being able to deliberate on the matter or vote on the matter. But in the case of mirror boards or identical boards in these companies, there could be a situation where there are no directors that are capable of voting on the matter. Excuse me. And so, when we're looking for possible solutions to sort of overcome this, we can look at Section 75(7) of the Companies Act, which states that a decision of the board is valid despite any personal financial interest of the director or related person if, one, it was approved following disclosure of that interest in the manner that's contemplated in Section 75. Two, despite having been approved, but without disclosure of the interest, it subsequently is ratified by an ordinary resolution of the shareholders and following disclosure to the shareholders of that interest. And three, despite having been approved without disclosure as well, it was declared to be valid by the court in terms of subsection 8. And so practically, scenario 1, this might not help in cases of mirror boards just because it's only possible where there are sufficient directors that are remaining on the board that would be able to vote after all the common directors have recused themselves. And so I guess the safest approach here would be for the directors to, disclose their interests, vote on the decision, and then have the resolution referred to the shareholders for ratification. And although this option doesn't fall squarely within that second scenario, just because in terms of that provision, there is mention of, despite having the decision having been approved without disclosure of that interest, and we're obviously suggesting that, the director should disclose their interests. We think, non-disclosure of the interests by a conflicted director could expose that director to potential liability for breach of their duty to disclose their interests. And even if the decision is ratified by the shareholders, it doesn't exclude the possibility of the director being held liable. So it's not necessarily ideal, obviously, for these, decisions that can be taken by the board, but because of technical conflicts, have to be referred to the shareholders. And in some of these instances, you'll find that the directors don't themselves actually have personal financial interests in them, but these still have to be taken to the shareholders, even if these technical conflicts do exist. And unfortunately, the issue also wasn't addressed in the Companies Amendment Act. So for now, I think we can also, companies can look to just ensure that, within their group of companies, there aren't too many instances of these mirror board situations or identical boards. And they can also look to just having maybe sufficient independent board members. And so lastly, I'll be discussing just the consequences of non-disclosure and non-recusal. So just taking it back to Section 75(5), this obviously sets out the steps that need to be taken in the case of where there are personal financial interests. So you'd obviously first just identify the personal financial interest that's held by the director. And for purposes of Section 75, a director does also include an alternate director, prescribed officer, and a board committee member. And So yeah, you'd have to identify the personal financial interest of these directors or of a related person. Then key to Section 75, of course, is the disclosure requirement and then the recusal requirement as well. And so what are the consequences for not following these steps? I think it's clear from a number of cases that I've set out on the slides and just the reading on the section of the section that a failure to disclose a personal financial interest as required in terms of Section 75 would render the transaction or the agreement or the board resolution that's passed void unless it is ratified by the shareholders or validated by a court. And so a practical question that could come up as well is, what if a director has disclosed their personal financial interests, but they sit in on the meeting, don't recuse themselves, maybe even go as far as voting on the decision. I think questions arise of whether, this resolution would, be rendered void. And we have some case law that I've put up there. It's the Hesper Impala case that does suggest that you can disregard the conflicted director's vote, but this also wasn't necessarily a legal question that the court, tackled head on. But what's clear is that, we don't suggest that you, this be taken as something that you can just ignore the recusal rule. It's very clear that in terms of Section 75, you are still obliged to recuse yourself if you are conflicted on the board. So thank you, that's my presentation. I'll now hand over to Lucinda.
Good morning, everybody. We're almost done. Between Andre and Yaniv and Roxanne, they did most of my hard work by explaining exactly what Section 77 and 162 is about. But what I'm going to talk to you about this morning is just some recent, one crucial development in respect of Section 162, and then also the two recent amendments brought about by the Companies Act to Section 77 and Section 162. So, as previously explained, Section 77 deals with circumstances where directors and prescribed officers can be held personally liable for losses sustained by the company as a result of a breach of the fiduciary duties. Now, Section 77(7) has a time bar clause, pre-amendment, that said that any such proceedings must be instituted within 3 years of the act or the omission that gives rise to this claim. Now, as Yaniv explained, the claim lies in the hands of the company. Now, this time bar didn't present or does not present a huge problem if the directors of the company decide that they want to proceed on behalf of the company against one of their co-directors, because they've got all the information. They've got access to company records, they've got access to financial information, so they have access to all the information necessary to bring such a claim. Now, if you just think back on the cases that was mentioned already, one of the things that almost each of the presenters said was the facts of these cases were very complicated. So you can imagine if a board of directors decide we've got no intention to go against one of our common directors, what must be done? Then it's left to a poor shareholder, a trade union, to follow a derivative action, to ask leave of the court to pursue this claim in the name of the company. Where are they going to get that information from? Litigating on a daily basis, I know that it sometimes takes years before you even see the inside of a court. So yes, somebody can say, but there's the PIA Act. So a shareholder and a trade union can deliver a PIA request. The company is going to refuse to comply with that request, and then the poor shareholder must litigate on it. The 3 years are gone in a blink of an eye. Think about the situation where the company goes insolvent. A liquidator is appointed after months, if not years, of an opposed liquidation application. That liquidator then still needs the time to investigate the affairs of the company, may have to go through an insolvency inquiry to find all of the information necessary to advance such a case. 3 years gone. The situation was made even worse by what the courts thought of the time bar clause. In the Nebevest case, which dealt with a derivative action, the court made it very clear that the time bar created by Section 77 pre-amendment is an absolute time bar. You cannot proceed after that. Shame, and the court really tried over time to help people in the situation of shareholders to try and make access to information a bit more available. And the one matter that comes up is the IBAX matter that again relates to Steinhoff. Steinhoff comes up quite a lot today, where certain media houses submitted a PIA request to Steinhoff to try and get access to the now famous PwC report. Steinhoff, of course, refused the request on the basis that the report was, according to them, covered by litigation privilege, and these media houses had to go to court, saying that they want access. Now, one thing that is very nice about this matter is the court reminded us of Section 70 of PIA, which is commonly known as the public interest override, which provides that even in some cases where there is a legitimate ground to refuse access to a document, if the company requesting the information can show that the public interest overrides the harm that the disclosure will suffer, it must be made available. So luckily in this case, the court found not only that the report was not covered by litigation privileged, but it also found that clearly the public interest in this instance overrides any harm which Steinhoff may suffer as a result of the disclosure, so the report was disclosed. But again, this was after a hell of a long fight, and the 3 years would have been gone. So luckily, and again, at least some good news for shareholders and trade unions, Section 77.7 has now been amended to say that the court may extend the 3-year period on good cause shown, irrespective of whether the 3-year period has passed and irrespective of whether the conduct that leads to a claim happened prior to or after the commencement of the amendment. So that's very good news for shareholders, trade unions, not so good news for directors for obvious reasons. The section specifically also expressly now provides that the Prescription Act does not apply to these type of actions. Now, the next question, of course, is what does good cause mean? Sorry, I was a bit too fast. What does good cause mean? Now, these amendments only came into force in about December last year, so obviously our courts have not been called upon to consider what this means in the context of Section 77.7. So we need to look at other cases, and one case that is almost on point is the Semancourt case, where the court had to consider a request to extend the time period set out in Section 8 of the Arbitration Act, which provides that an arbitration process must be commenced within a certain period of time. And in that case, the court looked into what factors must be taken into account, and we can see no reason why courts being faced with an extension request in terms of Section 77 may not look at the same factors. These factors included the extent of the plaintiff's delay. This amendment doesn't mean that you can sit back and wait for 10 years before you go to a court to ask for an extension of time. So that is one of the factors the court will look at. Also, an explanation of the failure to bring such an action within 3 years. There one can say, I had to fight the company in terms of PIA. I was a liquidator. I had to go through an entire insolvency inquiry to get the necessary information. The extent of the plaintiff's fault, That would be a factual inquiry. Then, of course, whether the defendant, in these instances the directors, whether they caused the delay. Again, one of the factors would be, I'm a liquidator, I was appointed after an application that was opposed by the very directors that I now want to go after. The directors blocked me, every time when I wanted to call them to an insolvency inquiry. Those are the type of things that a court will look at. The nature and the importance of the claim, and then, of course, the extent of the prejudice that will be suffered. So we can't see no reason why these will not be the type of factors that a court will take into account. Section 162, as was explained, deals with delinquency on the part of directors. Two important factors is that the section states that an application for delinquency can only be brought against a person who has been a director of that company within 24 months of the application. That was pre-amendment. And the section also limits and clearly sets out the category of persons or parties that can bring such an application. And it's limited to the company, a shareholder, director, company secretary, prescribed officer, and trade unions. So now you can imagine, if a shareholder, a trade union wants to bring this application, again, to get hold of the information to make out that case, 24 months gone. So luckily, the legislature has listened to the complaints and has now made two very important amendments to Section 162. Very good for shareholders, very bad for directors. The period of 24 months has now been extended to 60 months. And that is a big, big thing for directors to keep in mind. But it doesn't stop there. Even the 60-month period can be extended on good cause shown by a court. And we think that the factors that a court will take into account is going to be similar to the ones that we just discussed under 77.7. Even more bad news for directors. There's been a further development, and that is the parties that have standing to bring such an application. And we acted in this matter for Vantage, and the Hopeson that is referred to there is Mr. Hopeson Nomvete, that is also one of the respondents in the Delta case that was discussed. So not only does Steinhoff come up today quite a lot, but Mr. Nomvete also. So Mr. Nomvete and two others were directors of Somnipoint who owed our client Vantage in excess of 340 million rand. And we applied for Somnipoint's liquidation. Somnipoint was liquidated. We held an insolvency inquiry, and during that insolvency inquiry, it came out that there's a lot of evidence that the three directors of Somnipoint should be declared delinquent. We acted for the liquidators and for Vantage in that matter. So Vantage then issued a summons against the three directors in terms of Section 77, but also wanting to declare them delinquent in terms of Section 162. One of the directors took an exception to our claim, stating that on a plain reading of Section 162, a creditor cannot bring this application because a creditor does not fall within the category of persons in Section 162 that might bring such an application. Vantage then pleaded or relied on Section 157 of the Companies Act, which expressly makes provision for the extension of legal standing to apply for remedies available under the Companies Act. So we wanted to amend our particulars of claim. The director objected to the amendment. We brought an application for leave to amend, which he opposed, and that ultimately ended up before court. And in court, or the court then extended a creditor's right to apply for a director to be declared delinquent, and The basis was Section 157 that provides that when, in terms of the Act, an application can be made to court, the right to bring such an application may be exercised by any person, but here's the trick, acting in the public interest and with the leave of the court. So Judge Mannoim heard this matter and he relied quite heavily on the purpose of the Companies Act as set out in Section 7, which says or which encourages transparency, high standards of corporate governance as appropriate given the significant role of enterprises within the social and economic lift of the nation. So ultimately the court found that a creditor with the leave of the court has standing to bring an application to declare directors delinquent, but the court made it very clear it's not an absolute right. You won't always have that right. There must be a further investigation on the facts, whether it would be in the public interest to do so. So clearly in this matter, the matter was ultimately settled, so we'd never know if we would have gotten leave of the court to do this, but I think if one just looks at what the Delta judgment says, we probably would have. So that's my story. I'm going to hand back to Yaniv because I think there's a Q&A session coming now. Thanks.
Thanks for the presentation. It was really awesome.
Oh, pleasure.
I just have a question with regards to the personal disclosure of directors' interest in terms of mirror boards, where your directors could be conflicted in both the mirror boards. How do you manage or remedy that in terms of your disclosures?
Yeah, you see that that is a bit of a it is a gap in that Section 75 because it happens a lot. I mean, the directors of the one group company will be exactly the same directors as the other one, and now these two group companies want to transact with each other or give a guarantee for the other one. So the closest that Section 75 comes to that is it says if there's one director, and he's conflicted, then he can go ahead and pass the decision. You just need a shareholder resolution approving that. And I think one probably just extrapolates from that and applies the same type of principle. Let the directors vote on that, and all of them disclose their interest and then have a shareholder approval. It's not something, as Akona mentioned, admittedly, that's not something in the express text of Section 75. You almost have to just extrapolate from that 75 sub 3. And I think that's the conventional way to deal with it. Otherwise, you will not have a board resolution. You need a board resolution, and all of them are conflicted. So I think they must all vote, they must all disclose, and then you have the shareholders ratified. But Akona, I don't know if in practice, I mean, there are quite varying views amongst the law firms. I don't know if you've encountered other sort of approaches to that, but I think that is the conventional type of.
No, I agree.
That is the conventional type of approach. Yeah.
Thank you.
I think what is important is that you have to. It's really important to fully disclose at both levels, at the director level as well as the shareholder level, not just assume that the shareholders know what the conflict is.
Yeah. I think another point, although it's not really examined a lot, is the materiality aspect. So remember, the Section 75 is triggered if your interest is of a material direct nature. Now, a lot of parties don't really want to go into the sums and figure out if it's material for the counterparty group company, but it's still a relevant question. If it's not a material interest of the counterparty, Section 75 doesn't apply. But as I say, people don't really want to delve into that. They just adopt a conservative approach that it is Section 75, and then we just get it cleansed with a shareholder reso.
In many cases where you've got mirror boards, the resolutions will be written resolutions. So as Andre pointed out, it's important to disclose the financial interest in the resolution itself. And what we're doing is we also make those resolutions conditional. So in other words, they are conditional on the shareholders ratifying or the shareholders passing the resolution. And so that's just form, really. I mean, I don't think it's defective if you don't make it conditional. But when with mirror boards in a group company, often you'll just do it by round robin. So it's important in the resolution or in the introduction or somewhere in the resolution to disclose the financial interest. And then you can make the resolution, it's passed, but it's conditional on the shareholder approval at that, which is normally the holding company and relatively easy to pass as well.
Maybe just related to that, I think in the Atlas case, the point was made that you actually have to disclose all your financial interests, because I mean, you shouldn't just disclose the one that says, okay, now you can't vote. You actually have to disclose everything, whether the fact that you direct on both board, and then your shareholding above, you have to disclose everything, and not just think because you've disclosed one thing, you're now conflicted and you don't, but that's not good enough.
Follow-on question to that. In a private company, if the resolution is put to the shareholders and one of the directors or the conflicted director is a shareholder as well, and he carries a vote, how does that work?
Look at yeah, now it's fine. No, look, remember these rules around recusal, etc., they apply to the director in that capacity. So when you're talking about board resolutions, you're talking about recusals, conflicts of interest, etc. At shareholder level, when he's acting qua shareholder, he's not bound by those fiduciary rules. So can absolutely vote. Nothing precludes the director from voting, unless maybe there's very special circumstances there that show oppression. The courts can maybe intervene, that allowing the director to also ram through the vote as a shareholder. In the exceptional cases, maybe they could disallow him to vote at shareholder level. That would be exceptional, though. That would be exceptional, yeah. I think there was a question there, the lady.
Hi, thank you so much for the informative presentations by all the presenters. I just have one question which talks to the remuneration policy and report in terms of Section 30A and B of the Companies Act. And then in terms of the King 4 report is Principle 14. When you have a situation whereby the parent company is not founded in terms of the Companies Act, is founded through a different legislation. However, it has subsidiaries that are founded in terms of the Companies Act. Now, there is a requirement in terms of Section 30A and B for the subsidiaries to have the remuneration report as well as the policy. However, in terms of the main company, you don't have the legal requirement. However, through the board charter, you have adopted the King 4 report. Now, come reporting, how do you then go about it? If maybe you advise from a compliance point of view to say, by virtue of adopting the King 4 report, which is founded on the principle of explain and apply, you may maybe disclose the remuneration content and all that. I just need clarity there. Thanks.
Yeah, look, that entity that is not regulated by the Companies Act, so that's Section 30, all of that would not apply. Maybe that entity is regulated by its own piece of legislation, a founding piece of legislation, which might have something on director remuneration and approval. But if it doesn't, then it must consider whether it just applies a King, which is on a voluntary basis. And it would then just comply with those provisions. Maybe it could build something into its constitutional documents around that. But the point is, the Companies Act not only is not binding on, it's just simply not applicable to that entity. So it would just be a sort of a best practice thing in terms of King, and the governing body of that entity would have to decide to what extent it adopts all the principles of King, to what extent are the provisions of King relevant to that entity. I mean, King it's a voluntary code, but it is getting quite a bit of traction in the courts as a sort of a reference point for directors' fiduciary duties, and King applies to all entities, not just companies. It applies to statutory bodies itself, anything that has a governing body. So that would probably be the situation there. In terms of reporting, you would just look at best practice, how listed companies, etc., reported. One can get examples of remuneration policies in that regard. So I think you just adapt practices from other entities.
Sorry, just a question also on following on that on disclosure of the remuneration of directors. Andres, Yaniv, are there any suggestions or proposals around closing that possible loophole for just outsourcing? If you're a company, you outsource most of your other functions, and you leave yourself with only 30 highly paid employees, and then there is no disparity. But you've outsourced, a lot of what were originally employees' jobs, and now you're just contracting them out, and they're not your employees. So are there any suggestions or proposals around closing that loophole, or because it feels like it's very exploitable?
Now, Andre, not the first time you've been asked that question, that's for sure.
Yeah, I'm not sure whether you really can effectively close it, because there are legitimate reasons why people outsource. So you can't ban outsourcing, and so if you can almost carve it out that this type of outsourcing would not be allowed, but I would be doubtful whether you can do that.
The other point, look, that section is not enforced yet, the 30 cap A and B. We think maybe they're just supplementing that with the regulations, because you've got to put in the regulations. What does this policy look like? What does the implementation report? And let's look out for those regs. I think there's going to be something in there about this. It's actually not unusual for the regs to sometimes even go ultra vires, the act. It exists a lot currently. So they try to plug gaps in the act by doing it in the subordinate legislation, which you can't do, but you've got to apply it until a court sets it aside as being ultra vires. The other areas that also the JSE listings requirements can also, nothing stops the JSE from amending their listings requirements. This would be relevant for listed companies to plug that gap themselves. So one would have to see how that develops. But nothing that I know of. But I would suspect maybe something in the regs addresses this exact sort of thing, and they'll maybe expand the definition of employee in the regs, which I don't think they can do, but they've done those type of things before. Yes.
Thank you. My questions are to Andre, and it's also on Section 30 capital B. I think in terms of the employee definition, one will have to also look at the LRA, and it would include fixed-term contractors, but maybe not outsourced people. I wanted to ask your view on Section 61, which is one of the sections that came into operation and requires the presentation of the remuneration report at the AGM. So now, while 30 capital B not yet operative, how would you advise your clients on that? Can one just not read it into the Act and into the requirements for your AGM? And then we think there's a couple of drafting editorial mistakes in Section 30 capital B that was done in a hurry and put together in quite a hurry. So, for instance, the vote on the remuneration report and not on the implementation report, because the remuneration report includes the REM policy that you've voted on in terms of Section 30 capital A. Furthermore, we think that Section 30 capital B sub 4 sub B is a mistake. It shouldn't be there, because we think the intention was for a two-strike rule to apply. And that section is altogether confusing because, as you've said, the REMCO members aren't appointed by shareholders, but by the board. So we think that's just a mistake. It shouldn't have been there. We're still trying to lobby through BASA, through the Banking Association. We've also started some engagements through BUSA, trying to gather some support for amendment of Section 30 capital B. And finally, one of the other mistakes is really the fact that there's no exemption for public companies forming part of a group, similar to Section 72 for social and ethics committees. Just a couple of observations and maybe some questions if you want to respond.
Yes, I think the requirement currently that it is obviously a mistake that they shouldn't have provided that there should be a report of the remuneration committee that should not have become operative yet. I actually don't think it's probably impossible for companies really to comply with that because
Yeah, well, for the listed companies, actually doesn't change much. They do send a remuneration report anyway in terms of the listings requirements. So it's actually only going to affect the public unlisted companies, which is here and there you do come across it. So I think practically it might not be a pervasive problem.
Yeah, and even the presentation of these reports, I don't think, just generally the question is how do you now present it? But if you think about how do you present your annual financial statements at an AGM, you actually it's there in the report, and you allow questions in respect of that. So just that point. But yeah, so I don't think that I don't think unlisted companies would now suddenly have to report something on their and we're actually not sure when these provisions are going to come into force. So it might be quite imminent, unless you maybe have better insight than we do.
Not implemented to afford listed companies opportunity to be ready to comply because of the impact on the AGM, the sequence, your notices, conditionality of resolutions. So we think that they will be kind to the public companies and listed companies in terms of timing.
And hopefully when it comes into force, they'll give some transitional period, unlike what they've done with the Social and Ethics Committee appointment of members.
Okay, any other questions? Seems like that's it. All right, well, I just want to thank everyone again for coming through. Ian, sorry, you want to close off. Okay, thank you.
So thanks to my colleagues. A lot of hard work and effort went into this. We're actually running this again tomorrow morning in Cape Town, so everyone's jumping on a plane later today. And a special vote of thanks to all of you for joining us here today. I hope you found it informative. If you have any additional queries, please feel free to reach out to us. And if you do have the time, please join us for some refreshments on your way out on the deck. And the good news is a lot of effort went into this, but we've managed to get updated Companies Act booklets printed in time for this with the newer members. So to be clear, only and thanks to my team who put that together. So they will be available for you on your way out. They contain the amendments, obviously, that came into force, and in appendix at the back there are those that haven't come into force. So we're sort of hoping it'll be a while before those come into force and we don't need to print new ones. But please help yourself on the way out. You'll find them very helpful. We certainly do. Thank you very much.